Good afternoon, everyone. This is immigration attorney Kyce Siddiqi. I am based in Long Island, New York, and today we're going to be talking about the top 3 things that you need to know if you are a 2-year conditional green card holder. The top 3 things that you need to know in relation to applying for the actual 10-year green card and to remove the conditional basis of your green card. We're going to dive right into it. We're going to be talking about the top 3 things. The first is when to apply. The second is under what basis are you applying under. And third is how to actually apply for the 10-year green card if you are a conditional green card holder. Okay, so the first is when to apply. Well, if you are actually still with your spouse, if you are still married to the U.S. citizen, you want to apply within the 90-day window prior to the expiration of your green card. You don't want to apply before 90 days. I hear that quite often. Sometimes people mistakenly say, I got to apply before the 90 days of the expiration date of my green card. That's not true. It's actually within 90 days. So hypothetically, if your green card actually expires on June 1st, 2020, well, that door opens up on March 1st, 2020, when you could apply with your U.S. citizen spouse for the 10-year green card. Now, if you are actually applying under a solo petition or under the solo track, or you're all by yourself and you're no longer with your U.S. citizen spouse, or you're planning to actually get divorced, then that's going to be a little bit more tricky. So if you are no longer with your U.S. citizen spouse, or if your U.S. citizen spouse has passed away, you don't have to actually wait until the 90-day window opening up prior to the expiration of your green card. You could actually apply. So if your spouse passes away, I mentioned earlier the hypothetical, June 1st, 2020. Well, if your spouse passes away on June 1st, 2019, and you got your green card on June 1st, 2018, well, you could even apply on June 1st, 2019, the day that your spouse passed away. So as long as you apply before your 2-year green card is up, you could apply much earlier than if you would have applied under the joint track. If you're getting divorced, or you actually have been divorced to your U.S. citizen spouse, again, that 90-day window doesn't necessarily apply to you. As long as you're filing before the expiration of your green card, then you could actually go ahead and file well before the 90-day window opening up. Okay. Now, we're also going to now talk about the what basis, in terms of what basis are you actually applying under. We spoke about the when. The when is if you actually have a joint petition, you're still with your U.S. citizen spouse, it's within 90 days prior to the expiration of your green card. On the other hand, if you are applying under a solo track where you're no longer with your U.S. citizen spouse, well, it really depends. Are you applying because your spouse passed away? Well, you could apply any time before the 2-year green card expires. If you got your green card on June 1st, 2018, your spouse passed away on June 1st, 2019, you could apply on June 1st, 2019. You don't have to wait until the 90-day window prior to June 1st, 2020. If you actually are going to be applying solo and you're planning to get divorced, you could apply a solo track. You could apply as long as it's before the expiration of your 2-year green card. It's going to lead me right into talking about the second most important thing, is under what basis. We spoke about when, but what basis are you applying under? If you're still with your U.S. citizen spouse, well, that's easy. You have a good faith marriage, and you actually are going to now prove that by including a good number of evidence, whether that's joint tax returns, lease, deed, bank statements, life insurance, health insurance, car insurance under both your names. That is the basis in which most people who are going to be filing for usually joint petitions, you're doing it jointly with your spouse, you're going to be filing it within 90 days prior to the expiration of your green card. And that is based on the fact that you have a good faith marriage. A good faith marriage is defined as at the inception of your marriage, did you contemplate spending the rest of your life together? It's a valid marriage. The answer is yes. Now, if you are filing solo, well, then you have one of 4 bases to pick from. Either one, or you could pick 2 bases. But if you're applying on your own, you could pick, if your spouse passed away, you could pick the ground that your spouse passed away and include a death certificate. And we'll talk about how to apply in a few minutes. The second ground, or what basis, is that you had a good faith marriage, but that it ended in divorce. The third is your spouse subjected you to battery or extreme cruelty. And finally, the fourth basis is that you would suffer extreme hardship if you're removed from the United States. So, in summary, we spoke about when to apply. We just spoke about what basis, right? What basis is if you're filing jointly, you have a good faith marriage. That's what you need to prove. If you're filing it on your own, well, you have one of four bases. You could pick 2, 3. You could say, well, you had a good faith marriage and that ended in divorce, and that your spouse subjected you to extreme cruelty or battery, and you're going to suffer extreme hardship. If that's not the case, you could at least pick one. If your wife actually, or your husband had a good faith marriage with you and that it ended in divorce, and if the other 3 grounds don't apply, that's fine, as long as you pick one of those 4 grounds when you're applying on your own. Finally, the third most important thing that you need to know when you're applying for a 10-year green card is how. I mentioned it a little earlier. If you're filing jointly, you want to include joint tax returns, transcripts, joint bank insurance, health insurance, life insurance, car insurance, joint deeds, leases, joint gym memberships, joint Costco's, BJ's, Sam's Club's cards, joint credit card statements, as much as possible. Photos. Remember, they look at it in the aggregate and they make a determination in terms of the amount of evidence that you put. You want to cover the time period that you got your green card until the day that you're submitting. You also want to include some meat and potatoes from the time before that you were issued the green card, but you want to include as much as possible. This is for a joint petition. Now, for somebody who is applying on their own, they're no longer with with their U.S. citizen spouse, they have to apply. Remember, I mentioned one of those 4 grounds. Either their spouse passed away, or they're going to suffer extreme hardship, or that they were subjected to extreme cruelty or battery, or that they had a good faith marriage and that it ended in divorce. So, first one, if they are actually applying under the ground that their spouse passed away, well, that's easy. You're just going to include a copy of the death certificate. What about the ground that they're going to actually suffer extreme hardship? Let's save that for the end. What about the ground concerning extreme cruelty or battery? Well, we want to include, if applicable, police reports, domestic violence reports, things of that nature, family court reports, any kind of DIR or domestic incident report. These are important to show the extreme cruelty that you were subjected to, or abuse, battery. We also want hospital records, if that's applicable. If there was physical violence, we want to include those reports. And we want to include any kind of prescription that you were given in terms of any psychological or mental harm that you suffered. Psychological reports are very important to establish that you've actually suffered extreme cruelty or battery. Other ground, I mentioned that you had a good faith marriage, but that it ended in divorce. Well, you're going to need to prove the good faith marriage, as I mentioned a little earlier. Joint taxes, lease agreement, credit card statements, joint bank statements. You also actually have to include a copy of your divorce judgment. If you actually have a pending divorce, you're going to actually have to present that at the time of the interview. In terms of the last ground, extreme hardship, this is a ground that, from my experience, is somewhat tough to prove. USCIS officers themselves have emphasized that this is something in which we're talking about extreme hardship. Anyone is going to really suffer extreme hardship if they are going to get removed from the United States. We're talking about real extreme hardship, talking about like a debilitating disease, the treatment of which can't be actually administered in your country. So we spoke about when to apply, we spoke about what basis is, and we also spoke about how to apply. If you like this video, smash that like button, hit subscribe, and leave comments below. Thank you very much. And again, this is immigration lawyer Kyce Siddiqi. Feel free to call us at our office, 646-930-4488. We are here for you. Thank you.